Kiano na Wizara ya Afya.
Na NTV sasa, na tunaendeleza matukio ya leo ambayo tumekuwa tukiyafuatilia, hususan kubwa lao likiwa mashtaka dhidi ya naibu jaji mkuu Philomena Mwilu, na sasa hivi hizo picha tunazoziona ni moja kwa moja kutoka mahakamani. Tufuatilie kutujue ni kipi kinachoendelea kwa sasa.
Before, no objection was made as to the form and quality of the charge as required under section 89 of the CPC. To the direction sought by the DPP on whether she should respond to the application in view of the issues raised, it is my considered view that whenever an accused or indeed any person appears before the court, the primary responsibility of any court should first and foremost to accord that person the opportunity to speak out and even pour out their hearts or spirits on anything that worries them in respect to the accusations or the cases leveled against them. As a court that is keen to do justice in the case, formalities such as issues were raised without specifying under which law they were raised or premised upon should not be an obstacle to hearing a concern that a party is expressing. Indeed, under Article 159(1)(d) of the Constitution, the court is obligated to administer justice without undue regard to procedural technicalities. Hence, the mere fact that the application was made without specifying which sections of law it was brought until the tail end is not, in my view, a ground for saying that the issues raised are unworthy of reply. In my view, the state should have picked out any issues it believes it's worthy of its reply and leave those that it's of the opinion do not prejudice exposition. In fact, the issues raised by Mrs. Dorcas Orwell, though couched as matters which she seeks this court's direction on, are in a way a direct and unambiguous counterattack that could probably form part of her submissions, so that the court has an opportunity of considering if the said contradictions as to where she says the defense has argued about lack of jurisdiction and at the same time raised issues for consideration by the court, if any material consequence would arise out of that. In my view, I cannot, on the basis of issues raised by the state, dismissively hold the arguments or concerns raised through the application as unworthy of any response or consideration by the court. It is the best way the accused or defense could present the matter to the court, and the court has an obligation to consider and tell them whether it has merit or not. For that reason, the decision, if this court for that reason, the decision should be left to the state choice. It may choose whether to respond or not, but ultimately the court cannot and will never turn away its ears to a party's concern. Hence, even if the state chooses to exercise its right not to respond, the court must make a decision on issues raised before moving to the next stage. Orders accordingly.
Your Honor, we have since extracted the order in petition number 259, 2018, 295. 2018, we have served the DPP with the order, and my learned friends for the secretaries also seen the order and interrogated. I will now deliver a copy to the court. No, take this one, the seal. The one I'm giving the court has got the seal and stamp of the court. It's not a copy, it is sealed, a proper copy. And invite the court to look at, more particularly, the order number 5. which stays these proceedings and also set out other orders for purposes of preparing for the hearing of the petition. And there's a mention on the 9th of this month, of October, on which day the court will give. On 9th of October. And further directions will be given on that date. So not only have we, there's a stay, and on top of it, evidence to show that the matter is now actively before the High Court. So, Your Honor, I'll sit and let my colleagues respond to it. My view in respect of whether there are any directions now to be made on the basis of the application that we made orally, on the basis of this order, which stays proceedings in this matter. Again, as I said in the morning, if there was any reason to down our tools, now we have no alternative but to down our tools, including the tools of the Director of Public Prosecution. In this instance, you can do the others. But this one, down the tools.
I have been served with a stay order, but a casual perusal of the orders number 5, which reads as follows: that an interim conservatory order be and is hereby granted staying criminal proceedings against the petitioner in criminal case number 292 of 2018 pending before the Magistrates Court. That is not the case you're dealing with today. That's the wrong number. So these proceedings have not been stayed. These proceedings are number 38 of 2018.
They say number 38. Yes. The number.
Your Honor, just to help the court, if you look at the charge sheet, there's case number 292 of 2018. They are the ones who instituted the proceedings. And it is not us that gives numbers. And all that we were given was this charge sheet. There's a case number, then there's a court file number. But more importantly, and I think this is a point which we should not take time, the charges are signed by the Office of the Director of Public Prosecutions on the 28th of August. Yesterday, you know, the accused person was brought here yesterday, and there's a charge sheet signed by the Director of Public Prosecutions and also signed by the officer in charge of the police station is not. And finally, Your Honor, you can look at the court file and determine whether the charges in this charge sheet are not the same as the one in the court file. And secondly, you can also confirm that this case number 292 and 38 and date to court. It even talks about date to court, 28th of August 2018. And then the parties. The parties are here. I may want to introduce Mrs. Dokos Oduor to the Deputy Chief Justice of Kenya, if she, yeah, the parties are there. And Stanley Kiima is here. And then Your Honor, you just referred to Article 159 of the Constitution. If ever there is a question of a technicality or error, whichever way you consider it, then it is that one. But we stand guided.
Unless what is saying, she has other charges against the Deputy Chief Justice in another case.
Sorry. Your Honor, with due respect to everybody, this is a court of law and this is a court of record. What goes on record must be correct. It is for posterity.
These proceedings have not been stayed because the case that has been stayed is number 292 of 2018. So as far as I'm concerned, unless I am served with an order that reads that 38 of 2018, I do not think that this order included here will apply to this case. Because I also don't want to amend the order of the court. As a court, I cannot amend an order of the High Court. That would also be trespassing on other dangerous areas. I'm only guided and I can only be bound by an order that is clear and specific. So this order, in my view, does not apply to this case. I'm not going to be bound by this order. I would rather that, because if I do that, this order, it means if there is a case in the registry, number 292 of 2018, that is the one that has been. Because you see, there is a problem. The order must be specific and it should not be subject to any interpretation by this court. It must be specific so that the court can comply with an appropriate order. I would note it and comply.
The institution being what it is.
Yes.
We can
Before the same court to seek a correction.
Okay, then you make my position on this. A language that is understood. You cannot reserve the order and then you start moving for interpretations. or making your own positions. You must write the court in terms of the order. That is very specific.
You see, the only problem was through the courtesy of the prosecution.
I understand.
Yeah, we were given this charge sheet.
Well, my assumption, or I may assume that there could be an error, but you see, I'm not supposed to assume when you are serving the amount that is not senior than you know that. But what is that number? You must be very specific.
The number of the charge sheet. Yeah. You know, then we address you on what the court should do in the circumstances.
Case number 292, 28.
Just correct. No, the problem is, if in the body of the petition, there's a number of years. Yeah, probably we won't want to change it.
That's how it's treated. It's the church that was printed.
No, but it could this one. But it's not saying chief judge's case number.
Can the registrar be able to enter the judge's chamber and the whole body?
I think they almost get more.
Body must be done.
Sorry.
Question number 295/2018, the relevant order that the defense says touches on the progress of this case by staying by the granting amount of stay is order number 5, which reads and assures that an interim conservative order being disclaimed by granted staying criminal proceedings against the petition in claim number 292/2018 pending before the Chief Magistrate Court of Nairobi until 9 October 2018, when the court will give further directions of the petition. It has been pointed out by the state that the case before the court is number 38 of 2018, and therefore this order does not apply to this case. Indeed, looking at the file before me, that is a position. Court orders must be specific and should never leave room for interpretation. Consequently, I agree with the state that this order cannot apply, or neither is it an effective stay of this case, but considering that parties have since morning been talking about a petition pending before the High Court, I'll be ready to invite submissions on the same. On what you purport to be the error. So I want us to. I know that sometimes mistakes do occur, but I want us to have it on record before I make a decision on that. I want to have it on record, properly on record, as indicated by Mrs. Dorcas Odwall, that this is a court of record, and any decision that is taken must form part of the record. So I think it would be necessary, if you have any issues that you want this court to look at in view of that decision, I get information on this so that I'm able to decide and give a way forward. Because if I take this order as it is, it cannot be the order that stops this case. It cannot. If we take it as it is, either we have you agree that if you believe it's a genuine mistake, you are able to secure a proper order that is be served in to this court, so that the court can take notice of it. But the order you've presented to the court is not an order that the court can take cognizance of.
Your Honor, do you want us to address the court?
So is it something that, what's the position of the state?
I will not respond to that and let the court make a decision on it, but I have another matter to raise after that. I'll not respond to the issue of the order because I've already made some questions.
Yes,
they raised the question.
What was the issue?
The second issue I was going to raise is that if you look at the order at 5, the order is just in favor of the petitioner, and I would like the court to give directions on how to deal with the second accused person, who is the interested party. The order is for the petitioner but not the interested party.
We have issues there. We have some issues there. I don't know how. I think there are issues. There are issues here that needs to be addressed.
Yes.
Yes. I think there are. If you did, you have obstructed this order. There are some flaws in it. There are flaws in it, and I think.
Your Honor,
fundamental.
if we can address you then.
Yes.
On the issue that she has raised about this order.
Yes.
Your Honor, normally citation of a criminal case is not just saying criminal case number 50, let's say of 2018. Normally a citation of a matter which is before the court would cite the court saying the chief magistrate's court number.
Yes.
2018 of 2018. The 292 speaks to the charge sheet, the number given in the charge sheet, which is addressed as case number and is in bold, which means as far as this charge sheet is concerned, the number is 292 of 2018. This is the charge sheet that we were given yesterday. And Your Honor was not in a position to entertain any further proceedings because of the time the matter had come to court. So we left this court on the basis of the charge sheet. And that is what we used for the purposes of the application. So you could see in the order is not talking about chief magistrate's criminal case number. It's just saying criminal case number in reference to case number 292, which affects the petitioner. Now, it is quite clear that both in terms of the address we made in this court, it was on this charge sheet which is before the court. What went before the High Court was the same charge sheet which I have here in the bundle.
Okay, if I may cut you short then.
Yes.
So your submission is that the details contained in order number 5
Yes.
is actually an error. It's purely an error, a technical error.
Yes, it's a technical. Yeah, is in an error in terms of what has been instituted in this court in terms of case number, but it's not an error because that is what the police.
So in the orders that you prayed for in the High Court,
Yeah.
If I may ask, you asked for a specific order with regard to criminal case number 292 of 2018, and not 38 of 2018.
292
Yes.
in respect of the case file. But it talks about where the case is. The case is before the chief magistrate. Please. If you look at the order, pending before the chief magistrate's court.
Well, you know,
But Your Honor, I think if it is our desire to do substantial justice,
you may still have to go back to the same judge with maybe an amended application so that that order can be amended if that order really applies to this case.
So, Your Honor, then we'll seek for an adjournment of these proceedings, because this is not something that
so
you can ignore.
Okay, proceed.
And, Your Honor, if it pleases the court, we come the day after tomorrow.
So the purpose of the adjournment is to
The purpose of the adjournment is to bring an order from the High Court speaking to the issues that have been raised. It is just the number, the case number.
I believe the state can respond to that.
Okay. The other limb I'll talk to after.
So you have heard what the issues are. They have made the point that this is purely some kind of human error, and they would want to go back to the same judge so that the judge can rectify, or the order can be amended. What is your response?
We concur.
Much obliged.
So that is not enough. Okay, now let me make orders now in this case. So effectively, even as we raise, this case is not yet stayed. The accused persons are still subject to the jurisdiction of the court. Yesterday I gave them some personal bail, which I said was temporarily. Now, I don't know whether I should maintain the same terms.
Your Honor, I was going to plead with you.
Yes.
Normally, recognizances of bail.
Very well. I think in view of
I think for
this
Friday,
development,
yeah.
and the fact that we are now in agreement that probably what has happened is an
Yes.
error, which I think is possible. Human beings are to error. I think it is important that we give the High Court an opportunity of putting the record straight, so that we also don't end up doing something that is not worthy, something that is not necessary. So I think what we need to do is we can adjourn and then we meet again on which date?
Friday. Friday is okay. Yeah. Friday is the 30th.
Yes, 31st.
31st.
Yes, 31st.
We come at 10. Or we come at 11. We come at 11. No, we don't want this thing to be hanging.
If it hangs too much. Yes.
The appreciation is in my heart.
So, say the mention on
Friday at 11.
Friday is which date?
Your Honor,
That's the first.
I was going to ask, and I know we have really asked for so many things. Since the appearance on Friday is just for purposes of rectification of the record or amendment, I was going to pray to the court that the appearance of the two accused persons be dispensed with. Because it will not be an appearance on the basis of what bail and bond are for. And in the circumstances, we can take a mentioned date.
Yes.
On Friday, because I don't want to talk about the order from the High Court, we can take a mentioned date which is synchronized with the mention which the High Court has.
The State, do you have any objection to that?
Sorry?
Do you have any objection to dispensing with the attendance of the accused persons?
You know, the reason being that we do not know whether the order will come and whether it will be in that order or to that effect.
We can make her available.
The Criminal Procedure Code is very clear about first appearance and the responsibility of the court. We do not know how the order will read.
Many times, these courts dispense with appearance, yeah. And then this is the circumstances where it should be dispensed with. This is an office of the court. I believe that if it had something to do with me.
I think you are making so many requests.
No, this is the only request.
I've really accommodated you.
This is the second request, really. the first one was on account of what after
Mentioned on
interrogation.
31st August 2018. Please, let's not get into so much of this. Let's agree that proceedings are adjourned to give the High Court the opportunity to put the record straight with regard to the apparent force in the order that has just been served on the court. Accused persons shall, in the meantime, maintain same bail terms until then. Mention on Friday at 11 a.m. And I think that is all.
You're much obliged.
Yeah.
It could have been worse.